Hello, thank you for joining us. My name is Seth Maskett. I'm a professor of political science and director of the Center on American Politics here at the University of Denver. Thank you for joining us for a discussion on the future of choice, Dobbs, Roe, and reproductive freedom in the United States. I want to thank Katie Aker for her help in putting this together on a fairly short notice, and also want to thank Naz Barma and the Scrivener Institute for their support today. A week ago, we learned that a draft opinion was circulating in the US Supreme Court in the case of Dobbs v. Jackson Women's Health. This draft indicated a majority of the court was about to overturn Roe versus Wade and essentially end the country's half-century commitment to legal abortion. This opinion is not yet final. That should come over the next few weeks, but it seemed likely enough and important enough that we felt it necessary to have this conversation now. Obviously, this decision is already having profound effects across the country in terms of policy, politics, healthcare, and more. Roughly half the states are poised to immediately ban or sharply restrict abortion. Some states are considering restrictions on Plan B pills, contraceptives, and other things suggested by the ruling in Dobbs. To get a sense of what abortion rights and privacy rights look like in a post-Roe world, we've assembled a group of scholars covering a range of important areas of expertise here today. I'm going to introduce them now. First, we have with us Amanda Hollis-Brusky, who is an associate professor and chair of the politics department at Pomona College in California. She teaches and researches on American politics, constitutional law, and legal institutions. She's the author of Ideas with Consequences, The Federalist Society, and the Conservative Counter-Revolution. We also have with us Joshua Wilson, who is a professor and chair of the Department of Political Science here at the University of Denver. He's the author of 2 books on abortion politics, including The Street Politics of Abortion, Speech, Violence, and America's Culture Wars. He and Dr. Hollis-Brusky are the co-authors of Separate but Faithful, The Christian Right's Radical Struggle to Transform Law and Legal Culture, which came out last year with Oxford University Press. Finally, we have with us Jackie Del Castillo, who is a research fellow at IRISE, the Interdisciplinary Research Institute for the Study of Inequality, which is here at the University of Denver, where she studies and engages with health social movements globally. She also advises institutions and funders on supporting social movements for health equity and social justice issues, working with such organizations as the Mayo Clinic, Equalities Health, and the Nesta Health Lab. She has a recent PhD from the Institute for Global Health Innovation at Imperial College London. So we have about an hour together today. I'd like to start this hour by giving the panelists a chance to spend 3 to 4 minutes each, just giving us an idea of their initial thoughts on the Dobbs decision and what we should take from it. After that, I have a series of questions I would like to ask our panelists, and I'm going to reserve roughly the last 15 to 20 minutes of this hour for your questions. If you have a question for our panel, please use the Q&A button at the bottom of your screen. I'll be reading through and getting as many of those as I can. Amanda, would you like to start?
Sure. Thank you, Seth. Thanks to the Center for putting this together. As we say, on short notice, but it feels like at least a month since this opinion leaked, even though it's been only a week. Many of you probably feel that there's been a seismic shift in our politics. Much of my work on the conservative counter-revolution, on the Federalist Society, and our recently co-authored book, Separate but Faithful, sort of talks about the long road to Roe, right? The road to overruling Roe. But what I want to focus on in my opening remarks are sort of something to think about moving forward. And we'll get to kind of the long road through additional questions. But something that you may have heard from prominent Democrats, particularly prominent senators like Elizabeth Warren, Kirsten Gillibrand, Amy Klobuchar, they're all calling to codify Roe in federal law. You may have heard this, codify Roe. And most prominently, they're looking to pass the Women's Health Protection Act. So you may have seen this as WHPA, WHPA. This was a piece of legislation introduced by Judy Chu, who is my senator here in Claremont, California. I'm sorry, my member of Congress here in Claremont, California. And it was introduced in June of 2021. And the Women's Health Protection Act looks to federalize abortion protections using a very interesting power in the Constitution called the Interstate Commerce Clause. Now, I know when I talk about interstate commerce initially, some of my students' eyes will glaze over. They're like, this sounds arcane, technical, and boring. But the Interstate Commerce Clause is actually the primary vehicle through which Congress built the administrative state, the regulatory state, and through which Congress has extended its reach into areas of social and economic life, including the vehicle through which it passed the Civil Rights Act of 1964. So how is Congress looking to protect abortion through interstate commerce? Well, as it turns out, abortion is interstate commerce, right? Commerce among the several states. As the Act notes, women travel across state lines to get abortions. The medical equipment that's used to provide abortions and support abortions all travels across state lines. The licensing and educational requirements for abortion providers are all interstate by nature. And so using this reasoning and rationale, Congress is arguing that it has the power to protect a woman's right to choose an abortion because abortion is interstate commerce. Now, this sounds not unlike the reasoning it used to promulgate the Civil Rights Act of 1964. How is it that Congress had the power to tell a barbecue owner in Alabama that they had to desegregate their lunch counter? All right, where in its enumerated powers does it get that? Well, Congress reasoned that barbecue owner might be wholly in Alabama. However, the hamburger meat that they serve crosses state lines and therefore makes it a product of interstate commerce. They use the same reasoning to desegregate a hotel in Atlanta, Georgia, because it existed on an interstate and many of the travelers and patrons cross state lines. That hotel was subject to Congress's power under the Commerce Clause. So the reasoning and rationale have a pretty long history, dating back to the Civil Rights Act of 1964. So you'd feel like it'd be on solid constitutional ground. One of the things I write about in Ideas with Consequences is that the Commerce Clause has been one of the primary clauses that conservatives have attacked and tried to narrow the scope of federal power, right? Because narrowing the federal commerce power narrows the federal regulatory state and accomplishes a lot of these goals that conservatives have had. So there've been a series of decisions beginning in the mid-1990s where 5 conservative justices on the court have effectively pushed back on Congress's commerce power and narrowed the area in which Congress can act. What is commerce? What affects commerce? And so we have to keep in mind that the Women's Health Protection Act, even if it were to pass somehow, would then be subject to judicial review by the same 5 justices who we believe are ready to overturn Roe versus Wade. But let's say it passes. Let's say the Supreme Court looks at it and says, you know what? Clearly abortion is interstate commerce. We're going to let this one go through. One of the things we know about the commerce power is that it's been interpreted as far back as the 1800s to be the power not only to regulate something, but also to prohibit something. So if the Supreme Court indeed rules that abortion is interstate commerce, then a Republican Congress could come in and use that same power to ban abortion nationally. That means not just leaving it to the states where abortion is legal in California and Massachusetts and illegal in Louisiana and Texas, but outright banning abortion using that same interstate commerce power. It's the same way that Congress bans certain controlled substances and certain drugs, right? The Controlled Substance Act is based on interstate commerce. And so just flagging that for folks who are thinking, well, it's all right, we'll just go back to politics and we'll protect Roe and federal law, that number one, we still have a very conservative Supreme Court who's unlikely to uphold that as an exercise of Congress's commerce power. And number two, even if they do, Republicans would absolutely seize on that same power as soon as they got control to potentially ban abortion in all 50 states. So those are sort of my prefatory remarks, but I look forward to the conversation.
Thanks so much for that. I appreciate that. Jackie, I'd like to go over to you. And first of all, thank you for joining us from the United Kingdom. Sorry, things are so late there. But I'd be curious to hear your initial thoughts on this.
Thank you, Seth, and thank you so much for having me. I thought I would start by talking about three primary reactions. The first is basically that what we are witnessing and experiencing now is really the current result of a very long-standing, what we call dialectical, primarily kind of conflict, what has been across many decades. And these two movements have created a reason really for all of us to explore what we mean by issues of reproduction and abortion. And until this issue is reframed in a way that can accommodate more interest from all sides, it is a longstanding debate that we will continue to experience and witness and see the implications of. Depending on where you live, your income or your race, you're likely to experience the impact of this decision in a whole variety of ways. And so, unfortunately, very unfortunately, the ruling would likely exacerbate existing health inequalities, with people in states supportive of abortion having greater access to abortion services at a lower cost than those who do not live in supportive states. So, as was already mentioned, this would mean people essentially leaving, having to leave states of low income status and not having the means to actually do so in comparison to people of middle or high income status. And in fact, I'm getting a message here. My signal. Is it at all better? It's good? Okay.
That's a bit better, thanks. Yeah, okay.
Okay, fantastic. Sorry about that. But there's important things to highlight. I know we're going to get into the inequality of the decision further down the line with some of the questions asking, but it's important for us to recognize that there's so many factors or kind of an interest or not, like healthcare access and quality, a person's financial support ability, and a willingness to be pregnant. So it's not as simple as choosing to be a parent or not. Factors are as equally important: access to a living wage, access to insurance, race, gender, and food. An unprecedented setback, or could have an unprecedented setback for women's health and women's rights, and also for everyone impacted by reproductive decisions. But it is also important for us to also recognize that it is an unprecedented setback for health innovation. Now, what I mean by health innovation is new products, services, processes that have been able to transform the experience and delivery of receiving reproductive health care. And some of those benefits that have been achieved as a result of those innovations have spilled over into many other women's health and arguably health for all of us, which I could give examples of. And so essentially what we're seeing in the midst of this particular decision are numerous digital health startups, startups such as that are actually set to play a role of some kind in a more complicated picture if this decision were to go forward, which is very complicated essentially because some of the startup founders are also activists. I'm going to turn off my video to see if this helps. And so, if this decision were to go forward, the nature of innovation would likely, for example, with the innovations being more focused, for example, on access issues and access issues across state borders, which arguably could be viewed in a positive light, that we would be getting more accessible tools and education and services. But at the same time, important to recognize the implications of some of those types of innovations, such as telemedicine, for example, which can only be offered to uncomplicated early pregnancies, for example, which are disproportionately offered to certain groups. So important to recognize innovation in all aspects, that essentially all underrepresented groups are involved in the development and distribution of those. So I apologize for the choppiness, but I hope me turning off my video has helped a little bit.
Thanks. Sorry about the signal issues there. Josh, I'd like to go over to you at this point. What are your some initial thoughts on this?
Yeah, sure. And thanks for having me. So one of the things that has come to mind for me is just thinking about the future of abortion politics. If Roe is either overturned, as we're seeing in the leaked draft opinion, or if it's even just severely curtailed so that it's effectively overturned, but some sort of kind of fig leaf is left out. And so there's a few thoughts that come to mind. And one is how the overturning of Roe stands to really change a lot of things about abortion politics, but also leave many things in place. And so the standard arrangement that we've seen over the last 40 or so years is that anti-abortion activists have largely been in the driver's seat of abortion politics. And the reason why is, of course, because Roe secured the right to abortion. And so then the anti-abortion movement was in a position to constantly experiment with different forms of legislation to try to chip away at Roe. Or even in the early days, there were some kind of frontal assaults on Roe to try to overturn it. So they've really been in the driver's seat for the vast majority of time. And the typical pattern is that anti-abortion activists will target friendly conservative state legislatures. And those become the laboratories of experimentation where they offer up new forms of policy. And that's what I mean by the driver's seat component of this. And so then abortion rights activists have largely been in a responding position for the majority of time here. And so abortion rights activists wait and see what anti-abortion activists get through conservative state legislatures and then respond. And the form of that response is typically in the courts, right? So through litigation. And depending on where that court case goes to, if it goes up to the Supreme Court, that then tends to reset the parameters for political possibilities and then restarts the same cycle, right? Anti-abortion activists consider what the court has said, consider what they can do moving ahead, and again, approach friendly conservative state legislatures, and we repeat the cycle, right? If Roe is overturned, it's going to change a lot of that calculation or some important parts of that calculation. One of the things that's really important to notice is that both sides of the movement, or both movements, both sides of the debate, will actually have more room for going on the offensive in friendly state legislatures. So once you remove the right to abortion, then abortion rights activists have a space where they can move forward in progressive states to ask for the overt protection of abortion. So we even saw this already in the state of Colorado with the passage of the Reproductive Health Equity Act this session. Right? On the other side, anti-abortion activists, even if abortion is banned in their state and they presumably have what they want, there's still room to continue to go on the offensive, right? And so this is where we start thinking about, and we can already see this with some states, considering how they can try to regulate the behavior of women from their state who access abortion outside of their state. And so again, there are these kind of spaces to go on the offensive for both sides that we haven't really seen in the past. Another big change here is that conservative state legislatures are no longer going to be acting in a space where they know that the courts are a backstop. One of the things that's kind of made room for conservative states to act aggressively against abortion is the knowledge that if they act aggressively, it'll likely get shot down. So they kind of have almost a win-win scenario here in some ways, right? They can act really aggressively in the legislation that they pass, and they can use that to speak to their constituents to say, hey, look, I'm acting on behalf of your interests. But they know that it'll, in all likelihood, be shot down by the courts. And so there's not the worry about the backlash of if this actually really does go into full effect. In a world without Roe, there's no longer that backstop. And so conservative legislative members need to recalculate the political risks that they're exposing themselves to by moving aggressively against abortion access in a world that doesn't have abortion protected as a fundamental right. And so that'll possibly change some calculations. And we need to kind of see how this plays out in elections as well, because that's more information for legislators to figure out how to act strategically. Another thing that I just want to point out here too is one of the arguments in Alito's leaked draft opinion is he goes after Roe in part by saying Roe didn't solve abortion politics. So there's the assumption there then is if you overturn Roe, then you solve abortion politics. And that is really willful ignorance on the part of Alito. Abortion politics won't go away. One of the things to recognize here is that the infrastructure that allows abortion politics to play out has been methodically built over the last 40 plus years. That infrastructure doesn't go away. It simply changes its orientation in relation to the new political contexts. So I don't expect in any way abortion politics to go away. I also still expect it to be very much a state issue as opposed to a federal legislative issue. Yes, federal actors will talk about it, but still the main action and activity around abortion politics moving ahead will remain in states. And so really, we need to talk about a broad range of variations in the future politics of abortion. But I'll stop there.
Okay, thanks very much for that. Amanda, I'd like to ask you a question that's really about public opinion and legitimacy. One of the things we've seen is that this potential ruling looks to be very unpopular. And now I know abortion is when people are asking about it in public opinion polls, it's very sensitive to question wording. People's views on it can really kind of bounce all over the place. But it seems like the actual overturning of Roe seems to be an unpopular move. And I'm just wondering, what are the potential consequences of that? What does a potentially illegitimate Supreme Court look like? Do you know of other cases where the court has gone really far afoul from where most of the public is?
Yeah, so that's an important question. And I think to give it a little bit of context, the Supreme Court has been in the middle of a slow-moving, slow-burning legitimacy crisis for a while now. In 2020, I was asked to testify in front of Congress in the House Judiciary Committee on a panel called Protecting Judicial Independence and the Rule of Law, the Causes and Consequences of Court Capture. That panel was scheduled. As it happened, Ruth Bader Ginsburg died 3 days before. And I showed up to testify in front of Congress, and the tenor of the panel changed dramatically. No longer was it about kind of theoretical risks, the perceptions of the justices being political, partisan, particularly the conservative justices being so-called captured by the Federalist Society, this organization that has become a de facto monopoly on selecting, credentialing, and grooming Republican justices since the 1980s. The panel became about, constitutional hardball, right? What it means for Republicans as voting was already happening in the 2020 election to select a nominee and effectively rush this nominee to seat them in order to change the balance of power in that one seat on the Supreme Court of the United States, right? And we all know what happened and how that played out. Mitch McConnell, who swore that there should be no judicial nominations in an election year when Justice Scalia died suddenly, and held that seat open until 2016, when Trump won the election and eventually filled that seat with Neil Gorsuch. Mitch McConnell changed his tune, and the Republicans, in sort of a straight party line vote, installed Amy Coney Barrett right before an election that handed Congress and the presidency to the Democrats. Right? That is striking and that is remarkable. And so those kinds of moves, what we call constitutional hardball, right? The fact that both parties have fought so visibly and aggressively over these open seats on the Supreme Court over the last 10 years or so, coupled with the fact that we now have not just an ideologically divided court, which we've had for a long time, but a partisan divided court. What that means is that every justice appointed by a Democrat votes to the left of every justice appointed by a Republican. And so those things combined create and generate the perception that the justices are nothing more than an extension of the political parties that are appointing them, okay? And we know from political science that when people believe that, they lose faith in the institution and the legitimacy of the institution suffers. I would argue that right now, the slow burning, slow moving legitimacy crisis has just, and Seth, this is for you, gone into warp speed. The leaked opinion, you know, what that insinuates about kind of the internal politics of the court. We can talk about that later. But more importantly, the opinion itself and how far that opinion goes to not only just overrule Roe, but actually create the scaffolding to overrule same-sex marriage, to overrule perhaps the right for women to access contraception altogether, to chip away at other LGBTQ rights, and also to kind of build the scaffolding of a right to fetal personhood. There's some language in Alito's opinion which talks about equal protection for fetuses, that if developed and taken seriously, Josh talked about going on the offensive, right? This is one of the ways in which if this is actually built up and accepted, then we have a constitutional right to personhood, right? That would create an equal protection right against abortion and carve out a space where abortion would no longer be possible. So Seth, I know you asked me about legitimacy and public opinion, but I do want to emphasize that it's not just this is unpopular, which it would be, right? We know that from public opinion polls, at least 69% of people think abortion should be legal in some circumstances. So it's not just that the Supreme Court's doing something that's politically unpopular. They're doing something that's politically unpopular in a way that seems deeply partisan motivated, that seems deeply intentionally connected to the Republican strategy to play constitutional hardball and pack the court with particular justices who at this moment are ready to overrule Roe. So I think that's the real danger and the real risk for the Supreme Court right now.
Thank you for that. That's really helpful. Jackie, I'd like to go over to you at this point. I mean, we've obviously heard a lot in the news about the political consequences of this possible Supreme Court decision. I'm hoping you can give us an idea of some of the health consequences. For example, we know it's been, for several years, it's been very difficult to obtain abortions in many southern states, some Midwestern states, due to lack of facilities, lack of providers. I'm wondering what this decision would mean along these lines. Does it mean fewer women obtain abortions? Does it mean the same number of people get abortions, but they're less safe? Do people drive from Oklahoma or Nebraska to Colorado? Like, what does this look like? And how does this access kind of intersect with geography, with income, with race, and so forth?
Thank you, Seth. Yes, so as I mentioned earlier, the ruling would likely exacerbate health inequalities, which is the biggest issue that we're looking at this point. With people in states supportive of abortion having greater access to services at a lower cost than those who do not live in states that would be supportive. And so this would leave people of low income status less likely to be able to seek an abortion in comparison to people of, let's say, middle or high income status. And we already know that a majority of people seeking abortions are living below the poverty line, and people denied abortions are also more likely to be in poor physical health. We also know, according to research, that marginalized groups such as people of color, people with disabilities, indigenous groups, for example, would be at disproportionate risk of dying if abortion does become illegal. And unfortunately, these are the same groups that are often subject to navigating a healthcare system that can be already inattentive and unjust.
Thank you for that. Josh, I'd like to go over to you at this point. I was hoping you could give us an idea of some of the historical context that brought us to this point. That is, some are treating this as kind of a bolt out of the blue. They didn't see this coming. Some are saying, oh, this has been going on since 2016. Others, this has been going on since the 70s or 80s. What led up to this decision?
Yeah, sure. Also, I wanted to tack on one thing to Amanda's response. First, and it's just very quickly, it's just that Alito also recognizes the threat to legitimacy in his opinion and spends quite a few pages trying to address it by essentially arguing that by overturning Roe, he'd actually be restoring the court's legitimacy, framing Roe as a kind of an act of judicial power in the beginning and thus needing to be reversed. Of course, everything that he levels at Roe could be leveled at this opinion, but still, I just wanted to kind of bring that up. As far as like where this comes from, and this is another way of kind of thinking about this in relation to what Alito wrote, one of the things that I was first struck with in reading the draft opinion was how this read like a list of claims made by the anti-abortion movement for decades, many of which are kind of problematic in various ways, given scholarship on the issue and so forth. But if we're thinking kind of practically about where this came from, this gets back to something I mentioned in my opening comments about this infrastructure that's been built over the last 40 plus years. And so there are various ways that you can see conservatives and definitely conservative Catholics, and some starts in white evangelical communities in opposition to abortion. But really, for a lot of modern history, abortion wasn't a big politicized issue in the way that we think about it today. That had to be built over time. And the building of abortion as a central hot button political issue in American politics runs concurrently with the rise of conservatism within the Republican Party. The thing that a lot of people don't think about is how the Republican Party was actually the party behind the liberalization of abortion laws. So, right, we had to get a complete changing in orientation of that party. And the way that happened was through the rise of conservative elements within that party, which were in part mobilized around abortion. And so the very short kind of history of this is you had to have changes in kind of theology in white evangelical circles to start convincing white evangelicals that abortion was an issue that they should pay attention to. This translated into, and this was part of bringing white evangelicals into the Republican Party as a constituency. And so abortion was used as a way of trying to capture what a lot of conservatives saw as being larger problems in US society and government. So this gets back to some of what Amanda was talking about with kind of the larger conservative movement against kind of the use of the Commerce Clause and so forth, right? So abortion was a very accessible way of packaging a lot of anxieties and criticisms of US government and US society. So then what gets built subsequently are activist networks at kind of a national level, and then activist networks at the local community level. You eventually also get the building, and this is something that Amanda and I talk a lot about, is the building of legal resources for the anti-abortion movement. And so you eventually get the creation of organizations like Alliance Defending Freedom and the American Center for Law and Justice, which litigate some of these cases around abortion. And so we have, and then we also have conservative scholars who have been, conservative legal scholars and so forth, who have been writing about abortion. All of these developments provide resources that both build a movement over time and then supply resources that you can see marshaled in Alito's opinion. He's able to refer to arguments that are familiar to people because they've been built and used over decades. And so while the larger politics of abortion has really been about the erosion of Roe through chipping away at the margins. And so there was, particularly in this case, until oral arguments, I think there was a good argument that we would again see a chipping away at Roe. But what we saw in the oral arguments were the conservative justices really searching around for a way to move in a big, substantial way against Roe. It looked like they were going to move against the viability standard and remove that. But what we saw in this leaked draft opinion is going even further, right? It's taking out Roe at the base. And so this is something that builds, like I said, from the rise of conservatism, from the building of conservative infrastructure in the terms of political organizations for electoral politics, and also legal organizations for in the courts, and then pulling from the larger conservative movement beyond anti-abortion specifically to really build out these legal arguments.
Thank you for that. I'm going to ask our panelists just a few more questions here, but I'd just like to remind folks at home, if you have a question for our group, please feel free to use the Q&A button at the bottom of your screen and type it in, and we'll do our best to get to it. I actually have a question for Jackie at this point. I'm wondering if you know of, are there other countries that have tried this? Essentially, where they have gone from a relatively liberal period of abortion access to suddenly being very restrictive. Has this happened in Europe, in Asia, South America, and what have been the consequences of that?
Yes, thank you, Seth. I have less information on that particular question, more if it would be helpful in terms of other countries that have looked to the US as an example, and we're now seeing the reverse situation that you mentioned, which is seeming particularly interesting in the context of what's happening now. So for example, countries in Latin America that have long looked to the US as a model for reproductive rights, and yet we're seeing that dynamic recently change with events leading up to this particular moment in the United States. So for example, in February of 2022, Colombia's constitutional court ruling in favor of legalizing abortion up to 24 weeks, followed by Colombia followed Argentina, and most recently Mexico in similar decisions. And basically Latin American activists have been talking about kind of this mindset shift that they have been able to instill over the decades in defending the right to abortion. Making the topic mainstream, for example, by encouraging people to at work, in cafes and bars, dinner tables, as well as strategically putting women in positions of power, both in government, but also in corporate settings, which is a whole other conversation that we could get into, to really expand mobilization and awareness of this struggle through people's stories. And I think there's a tremendous amount that we can learn from social movements in other countries, and in particular other health social movements. So we have written heavily about that in terms of what we can learn from other global social movements for health. So for example, in moving an issue from a private to a public issue, the breast cancer movement being a tremendous example of that, or reducing stigma, for example, related to mental health. There's been a campaign in the United Kingdom called Time to Change, which over the past 10 years has led to a significant reduction in stigma, using basically a research-based model of tracking kind of changes in behavior, knowledge, and attitudes over time. So I think kind of parsing out what is it that we would want to learn going forward, and then taking a very targeted approach at looking at what other countries have done would really be to the benefit of people, of activists here in this country.
Thank you. That's really interesting. I appreciate that. We have a question, and I want to direct this to Amanda. Just asking the question, is there a chance that Roe v. Wade does not get overturned, or is that definite at this point? And I'd like to sort of add a little bit to that, then, since we only know this from a leak, and leaks from the Supreme Court from a ruling that hasn't come out yet are incredibly rare. So, what has this revealed? Do you have a sense that this is being done to sort of test the waters, to see if this decision would be accepted, or or does this just look like it's happening at this point?
Yeah, that's a great question. If any of you follow like law professor Twitter at all, this is the question everyone's obsessed with. How did this happen? Who did this? Oh my God, this is just the worst thing that's happened at the Supreme Court, in 100 years. And there's a great tweet, and I wish I could remember who tweeted it out, but it's kind of commenting on this obsession with the leak. And this woman had said, yes, let's double down on palace intrigue while Rome burns. All right. And the idea there is, yeah, the leak is interesting. And I'll talk a little bit about why it's interesting. But what the leak says is what we really need to focus on. But let me take a step back here. The Supreme Court is a closed institution, right? Unlike Congress, we don't get to see how the quote unquote sausage is made. And in fact, because it's closed to the public, because these justices operate in a marble temple and appear, from behind a velvet curtain in long black robes, like some priests from on high, the Supreme Court has been immune from a lot of the criticism and the vitriol that has been levied at Congress for decades. The public approval of the Supreme Court up until recently has been consistently over 50%. And people theorize that's because they like it because they don't know what it does, right? People have a hard time up until probably a week ago. Fewer than 10% of Americans could name Justice Alito, right, as a justice on the Supreme Court of the United States. I think that's probably changed now, but this gets to the point that they are a closed institution that operates, behind closed chambers, and really critical to how they view themselves is the secrecy around their process, right? So the Dobbs case was argued on December 1st, and that oral argument was live streamed, right? That was a positive development from COVID, is that we got to hear oral arguments live streamed for the first time. And then after that oral argument, the justices would go in chambers and they'd take a preliminary vote. Are you voting in favor of the state of Mississippi or the abortion clinic? And depending on where that vote comes down, if the chief justice is in the majority, right, there are 9 justices. So if the chief is one of the 5, the chief assigns the opinion. John Roberts would assign the opinion to himself or would assign it to somebody else. If the chief is not in the majority, the senior most associate justice, Clarence Thomas at this point, assigns the majority opinion. So what we know from the fact that Alito wrote the draft is that likely John Roberts is not in the majority, voted with the liberals. And so the majority opinion was assigned to Justice Alito. Opinions always circulate, right? There's a tentative agreement. Here's the direction we want to go in. And then the majority opinion author circulates the draft to chambers, and each chambers can comment on it. I agree with all of this as is. I think you need to tweak these parts. I'm on board with parts 1 and 3, but part 2, I can't sign on to unless you made the following changes. These kinds of backdoors negotiations are never made public. Right? Well, never, unless there's a leak. So what we know from this draft opinion is that it circulated in February. It was stamped as circulated on February, but you see there's a next line that says next circulated and it's blank. So we don't know if this is the most recent iteration of the opinion. We don't know if there's another draft that had already been in the works and circulated around the chambers when this one was leaked. And we don't know if there will be further changes or not on account of this leak. Ordinarily, the Supreme Court, I was saying to my fellow panelists, ordinarily the Supreme Court waits to drop its big atomic bombs to the end of June, right? The kind of last days of its terms are usually the biggest, and then it checks out, it goes on vacation. This is unusual and also very inconvenient for those of us who are doing finals and trying to teach classes and wrap up our semesters. But so to answer this question, it's likely that this was never going to be the final product, but given everything that's swirling around this leak, I don't know if it pushes in a very different direction or keeps it closer to this product, depending on how hard the conservative justices want to double down on this, given what they're hearing and what they're seeing.
Okay, thank you for that answer. Jackie, I have one directed to you for you here. The question is, my understanding is that the end of Roe would also mean difficulty or impossibility of facilitating something very common, pregnancy terminations done in consultation with doctors in the case of non-viable pregnancies. For example, it's not uncommon for a fetal heartbeat to stop at 6 to 9 weeks. This can affect millions of Americans. Do you think people understand this? Should the abortion rights movement be making this clear to the public?
Yes, thank you for this question. I mean, there are many of OBGYNs, for example, physicians that are talking out about this issue, that there will likely be women that very sadly could die or will die as a result of pregnancy because of this decision. You know, in terms of whether enough people know about this, you know, I can't answer that question, but if we feel that there are people that do not understand this, continuing to get the word out is obviously extremely, extremely important. Also, you know, this what comes to mind too is just what I didn't mention previously is that, you know, the laws that would restrict abortion could also have implications for treatments for miscarriage as well. So essentially,
Jackie, I'm having a hard time hearing you. Can you try turning off the camera?
I think you lost me on the second point, which was basically that laws that would restrict abortion could also have implications for treatments for miscarriage. And so making sure that we get the word out about all of these various potential health implications is obviously extremely important.
Can I dovetail on that for a second? Yeah.
Sure.
So thinking about this, so Zaid Munson, who's another scholar who writes about abortion politics, refers to abortion as being this empty shell in American politics. And what he means by this is that most Americans don't have a very detailed understanding of what abortion is, kind of what falls underneath that umbrella, right? And so public opinion and public kind of ideas of what is involved tend to be pretty ill-formed. And as a result, it makes abortion as a political topic really pliable, that you can, essentially, we can look over time at how what abortion politics are about have been redefined over time. And what allows for that is this lack of a detailed, stable understanding of what abortion really is. And so I think that the reason why I'm bringing this up is I think it translates back to this question as well of how much does the American public actually understand about the range of issues within kind of reproductive health that are affected, let alone the wider legal effects of going after what has been recognized as a fundamental right through the 14th Amendment and so forth. So that's a whole nother can of worms.
Okay. Josh, I had one that came in that I actually wanted to ask you, asking about what we're seeing in terms of protest over the last week. We've seen the Supreme Court erect a barrier. There's a fence preventing people from protesting close to it. We know people are protesting in front of some of the justices' homes in the DC area. What do we see? You know, are these likely to be effective forms of protest? We know that people often protest in front of the Supreme Court, but I have no idea if that's considered anything that actually influences justices. I'm curious your thoughts on this.
Yeah, no, and I think today, it was either this morning or yesterday, there was also a vote to allow for protection of Supreme Court justices' family members as well, right? And I believe that was unanimously passed by the Senate. And so I don't know how much of this actually matters for the Supreme Court's decision. There's just a lot of speculation when it comes into there. Like Amanda was saying, a lot of what goes on in the court is is off limits to us, right? We might find out about some of these details later when a Supreme Court clerk writes a book or is interviewed for somebody else writing a book, or decades later when retired justices' papers are released and so forth. So it's really hard to know what factors into individual justices' decisions and decision making. The way then that I kind of think about these protests and so forth is really going back to what Amanda was talking about with kind of legitimacy of the court and this is an institution that doesn't like the limelight. It's an institution that likes to remain out of discussion and view. And when you have protests going on in front of the court, and now protests going on in front of individual justices' homes, this is really, these are signs of the ways that people are thinking about the institution and those individual actors, right? That they are these individual political actors that should be called out and should be pressured and so forth. And so it's just another sign of the way that we have really come to see the Supreme Court as a political institution, very much like the other branches. And that's a real shift in the public perception of that institution.
Thanks for that. Amanda, I'd like to go over to you. We have a question about what this ruling could mean in terms of some other longstanding rulings. I mean, if this actually erodes, seen as undermining the right to privacy, what does that affect? Does that affect same-sex marriage? Does that affect contraception? What else is potentially in the crosshairs here?
Yeah, Seth, and this has been another area where you see conservative law professors trying to downplay or minimize this threat that an attack on Roe means an attack on same-sex marriage, LGBTQ rights, access to contraception. And the argument from the conservative law folks goes like this: Roe was unique. Roe was special. Roe has long been thought of as probably the most egregious example of judicial overreach and constitutionalizing a right to abortion. That has no place in our Constitution, that has no place in our history and traditions. Obergefell, that's popular, right? People pretty much on board with same-sex marriage. The court's not going to go after that. I think that's naive and Pollyannish if it's being articulated in sincerity, and at worst disingenuous for a few reasons. If you read Alito's opinion and the rationale he gives for when the court should recognize an unwritten right, let me walk back and say, we have unwritten rights in our Constitution. Right? The 9th Amendment, written by James Madison, says explicitly, right, to answer the fear of some of the founding generation that if we write down some rights, that'll mean the government will think those are all the rights we have. And Thomas Jefferson said, I don't care, give me half a loaf. And Madison said, I'll do you one better. We'll get half a loaf and we'll write the 9th Amendment that says the rights not enumerated, right, shall not be construed to deny or disparage others retained by the people. So we know we have other rights. And the justices have had a variety of different ways of finding those, recognizing those over time. But the test that Alito uses in the draft opinion in Dobbs would restrict the recognition of any unwritten right to something that is deeply embedded in our history and tradition as a country. And he's specifically looking at the 14th Amendment and saying, if it weren't deeply embedded in our history or tradition as of 1868, we have no business recognizing it as an unwritten right. Now, by that test, the right to same-sex marriage is a whopping 7 years old. So the idea that the conservatives couldn't use this opinion in Dobbs to immediately go after and challenge same-sex marriage is disingenuous. The other thing I'll say from Josh and I's research, The same anti-abortion advocates who are fiercely anti-abortion are fiercely anti-LGBTQ rights, anti-same-sex marriage. It's part of that same culture wars bundle. And I would be shocked if states didn't start testing the court after Roe falls by passing marriage bans and trying to get that question squarely before the same 5 justices who would likely rule the same way.
Okay, thank you for that. Jackie, I think we have time for one more question. I'd like to direct it your way. There's a question that's come in that just asked, what would this ruling mean for non-invasive pregnancy terminations, like Plan B, like an abortion pill? How do you see this sort of playing out if this ruling stands?
So my understanding at this point from what I've read is that the basically overruling would not affect Plan B, essentially affects all methods of abortion, so would actually apply to the abortion pill.
Okay, and you had, I think, mentioned something about how I think there are some efforts to either, I've heard of efforts by some states to either possibly prohibit the sale of Plan B across state lines or something like that. I mean, I'm assuming all these things would be unconstitutional in the long run, but until then, I mean, do you know of developments along these lines?
I don't. I'm curious if any of you do.
Yeah, I would just jump in. I'm sure Josh has something to say here. Is think of SB 8 in Texas, which now places civil penalties on anyone who tries to aid or abet an abortion. And it doesn't limit it to people just in Texas. If SB 8 is allowed to stand and we're in a post-Roe world, states could pass copycat legislation, not only imposing civil penalties on anyone who aids or abets an abortion, does a telehealth visit from California with someone in Louisiana, for example, and then uses the federal mail to send the abortion pill. You're going to see efforts, and this gets into some of what Josh said, where states are going to go on the offensive to try to restrict their own citizens from accessing sort of new technologies and new abortion methods across state lines.
Yeah, and then on the flip side of that too, we're starting to hear from democratically controlled states of how they can protect their providers in their states from legal liability in other states. And so we're really setting up a dramatic future of state versus state here that can really affect the ability to move around the country too, right? Like if you're that doctor in California and you consulted with the patient in Texas, can you go to your cousin's wedding in Dallas without worry now, right? And so there's a pretty bleak future ahead here, and thinking about kind of state versus state. Yes, I'll leave it at that.
Okay, thank you all for this. Obviously, this is incredibly complicated, and we're just beginning to understand all the aspects of this as it unfolds, and there's still so much more to come. I really appreciate your time today as we figure some of this out. This has been a very useful discussion, and I really appreciate all you brought to this. So I want to just mention to our audience, we've been recording all this. We're going to make this publicly available sometime within the next few days on the Center on American Politics website. In the meantime, thank you all for your attention and for all your questions. I hope you'll please join me in thanking our panelists today. Everyone stay safe and be well. Thank you so much.
Thanks, Seth.
Thank you, Seth.
Thank you.